is going to be to work some bills that we have previously heard. The first one we're going to call up is a bill from our meeting yesterday, which is House Bill 2518. And with that, a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2518 increases the criminal penalties for certain violations of the crime of breach of privacy, and it also modifies the culpable mental state required to commit the crime.
Thank you. Committee, any questions? 2518, that's an easy question right there. So, yes, 2518. We'll give everyone a minute to dig that out. All right, any questions? All right, not seeing any. I did want to make a conceptual amendment. It's a usual one that you'll see on bills, and it is to change the enactment date from the Kansas statute to the, or from public to publication in the register. So if I have that right and you all understood that, is there a second? Senator Titus with the second, thank you. If there's no discussion, then you all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. We are back on the bill. Is there any further discussion or a motion? Senator Titus.
Thank you, Madam Chair. I move that the committee recommend House Bill 2519 as amended favorably for passage.
Everyone's thinking it's 2519 this morning, but it's 2518.
2518. Sorry.
As amended. Thank you. All right, if everyone's heard the motion and we have a second there, you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. And the reason we're working bills on the front end is we want to make sure we get our work done and on to the Senate as a whole as soon as possible. And so with that, then the second bill from yesterday that we want to pull up is House Bill 2594. 2594. And with that, a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2594 modifies the elements of the crime of blackmail relating to the threatened dissemination of any image, video, or other recording of another identifiable person who is nude or engaged in sexual activity. It changes the connection from the crime of breach of privacy and just describes that content again over here in the crime of blackmail.
Thank you. Committee discussion, or I'm going to make a conceptual amendment to change it to the enactment upon publication in the Kansas Register. Is there a second? Senator Shane, thank you. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We're back on the bill. Any further discussion or a motion? Senator Reichman.
Thank you, Madam Chair. It seemed like there was something about with people under 18 being blackmailed or something. Could you remind me exactly what this bill does? Thank you.
Sure, thank you. And I'll let the reviser explain.
Sure, thank you, Madam Chair. So in blackmail, we tie the elements to the crime of breach of privacy. And then we made a tweak in breach of privacy, which requires that the victim be over 18 years of age. So by doing that, we perhaps inadvertently, that's what you heard from the prosecutors at least, made it so that this crime of blackmail only applies if the victim is over 18. So this would just remove that tie and just describe the conduct. It's not changing the conduct's about the same, but just describing it over here so it doesn't have that link to the other crime.
Thank you. So does this apply to answer or to follow up on the senator's question, does this apply to someone who's under 18?
Yes.
Thank you. Any further questions? Not seeing any. Is there a motion? I'll go ahead and move that we recommend favorably for passage Senate Bill 2594 as amended. Is there a second? Excuse me, House Bill 2594. And I saw Senator Rose with the second, so thank you. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. The next we're going to take a look at is House Bill 2593. And while you pull that out, we'll have a brief summary from the reviser. House Bill 2593.
Thank you, Madam Chair. House Bill 2593 would require certain political subdivisions who want to enter into a contingency fee contract for legal services to get approval of that from the Attorney General.
Committee, any questions? I do have an amendment to offer. So while she starts passing that out, if you'll recall in testimony, we heard that in House Committee they had added a couple of amendments, and the testimony here was that those would be of concern. So if the reviser could explain.
Sure. Thank you, Madam Chair. So essentially, anywhere where you see the bold text, we're reverting that back to how it was when it was originally introduced. So on page 2, the House changed that the legal matter involving claims or issues that are more appropriately within the scope of state enforcement. They added a provision that says, as determined by the Attorney General in a written finding identifying the specific state interest at issue. You guys would be removing that, and you would restore the language of could lead to inconsistent legal outcomes or undermine the state's unified position. Again, the House added would materially and directly interfere with the state enforcement, and you guys would be removing that. And then in paragraph 3, the House added an appeal process, so the political subdivision could appeal the refusal of the contract, and you guys would be removing that appeal process.
Thank you. And I think the testimony we heard that was if the amendments remained, you would basically be having a trial before the trial. And there is, if this amendment were to be adopted, there is another amendment that would help clarify what the bill does and how it operates. But this is the amendment that we're on, and so it would remove kind of that layer, but would still require that there's still well, so that's the amendment. If there are any questions for the reviser or the carrier. Senator Reichman.
Thank you, Madam Chair, and I hate kind of being a thorn in the side here. I remember when we got done listening to people on both sides of that, I had nothing but a question mark. And so I'm going to have to listen to, and now, because some said that amendments they put on the House were good, and others said it was bad. And so I guess for me, I will still have to, I really don't understand what we're doing here, and I'm a little confused. Thank you.
Sure. So the testimony we heard, and this is the summary of it so we can get clarification, but the municipalities, I think, were concerned with the amendments that got put on in the House. And so to clarify and kind of bring the bill to where it was more acceptable to both sides of the issue, if we would remove the amendments as this amendment proposes, and then do have another amendment that's, I believe, favorable and supported by both sides. So trying to get the bill to a place to address the concerns from both sides so we can get a process in place for these kinds of litigation. Thank you. Is there a second on the motion? Do we have a second? Senator Bowers. Any further discussion? I'm sorry, I looked right at you and said Bowers, and I meant Bowser. Apology to both the good senators. And so if there's no further discussion, I'll go ahead and move the amendment. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill. And I do have that other amendment now. Senator Rose has a question or other discussion.
I have an amendment.
Okay, well, we'll turn to Senator Rose. All right, well, my turn then, I guess, again. So while that's getting passed out, the amendment, it's pretty straightforward. You'll see that before January 1st of 2027 and each January 1st thereafter, the Attorney General shall submit a report to the Governor and the Legislature regarding each instance in which the Attorney General refused to approve a contract. And you can see kind of what the report would entail. So that there's a reporting mechanism, there's an accountability mechanism to see if the review process by the Attorney General is being used appropriately, or just to provide some information to the legislature about how this process is working. So any further? And in addition, because this is a new process, thought it would be a good idea to provide some additional guardrails, accountability, and put a sunset in. So the process would expire on July 1 of 2031. So with that, any discussion or a second? Or a question for the revisor? A second from Senator Titus. Any discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. If there's no other discussion, I'll go ahead and make a motion that we move House Bill 2593 as amended favorably for passage. Is there a second? Senator Rose. You all have heard the motion. All those in favor signify by, if there's any discussion, we'll do that before voting. Yes, Senator Corson has some.
Thank you, Madam Chair. You know, I'll be a no on this. I do think that some of the amendments were helpful. I just fundamentally think that this is a decision that is best left to these municipalities to make. When we asked the Attorney General if there were instances that he felt like this had been abused or used improperly, you know, he continued to mention that case in Ford County that he's obviously does not appreciate that Ford County decided to move forward with that litigation. But to me, his objection was really he just politically disagreed with it. It was not really a legal objection. It's just he didn't really like the subject matter and he didn't really like the politics of it. So it was more, it just didn't kind of fit his personal political preferences. And I just think that is what something like this opens us up to, where you could have an attorney general in either party who would be approving or not approving these things kind of based off more of their political ideology than their legal merit. And that to me is, I think, problematic, and so that's why I'll be against it. Thank you, Madam Chair.
Thank you. Any further discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Thank you. We are going to now pull up and take a look at House Bill 2323. And it's regarding civil cases and insurance fraud. And with that, then, a brief summary from the revisor.
Thank you, Madam Chair. House Bill 2323 establishes procedures for civil actions initiated by the Commissioner of Insurance related to fraudulent insurance acts. It also provides that expunged criminal records will be disclosed in any application for licensure as an insurance producer or public adjuster if the arrest, conviction, or diversion is for a fraudulent insurance act. And it also includes automobile assigned claim plans and provisions related to fraudulent insurance acts.
Thank you. Any questions? Not seeing any. I do have a couple of amendments, and while she's passing those out, these amendments were brought to the Department of Insurance, and they are fully supportive of these. But before I go on, I will wait for them to be handed out. Okay, you'll see that the first one is changing the venue where these actions can be brought. And instead of only in the District Court of Shawnee County here in Topeka, you might be a defendant who lives in Finney County or whatnot. So the venue would be changed to any county in which the defendant resides or in a county in which the alleged fraudulent insurance act occurred. And also, fraud is an intentional tort. It's not negligence, so you're intending to do the fraud. And in our civil code of civil procedure in statute, you have to plead this allegations of fraud with specificity. So it was important to have the same allegations of fraud that you're going to put in the lawsuit. You state with specificity what those are, what was taken, when, where, those kinds of details. And then it also raises the burden of proof from preponderance of the evidence to clear and convincing. Preponderance of the evidence is kind of the lowest burden of proof that a litigant would have to prove, sort of 51% that you did it. And with clear and convincing, it's a higher burden of proof. And that kind of matches up again. Fraud is not negligence. It's not you didn't realize, but fraud is an intentional tort. So it was thought to be important that we raise that burden of proof to show you've got to prove the intentional act with clear and convincing evidence, not just, well, 51%, 49%. So those were the thoughts. If you have questions or want further explanation from the revisor, we can certainly entertain those. Not seeing any of Senator Reichman.
Thank you, Madam Chair. If I understand this right, you're going to make sure it's just not Shawnee, but it's all across the state, which I think is good. And then raising the bar to clear and convincing, I think is a good move too. So I'm going to support this. Thank you.
Thank you, appreciate it. Did you want to second it, or? I think you said yes, okay. Thank you. Any further discussion? Not seeing any, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill. If there's no further discussion, I would entertain a motion. Senator Titus.
Thank you, Madam Chair. I move that the committee recommend House Bill 2323 as amended favorably for passage.
Thank you. Is there a second? Senator Bowser. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, the next bill we're going to look at working is House Bill 2444. 2444. And with that, a brief summary from the revisor.
Thank you, Madam Chair. House Bill 2444 provides that jail credit when consecutive sentences are imposed shall not apply to more than one case. It also creates a special sentencing rule when a felony is committed by certain offenders while in custody for a prior felony or on probation, parole, or post-release supervision for a prior felony. It provides limitations on releasing people charged with a felony on the person's own recognizance, and it also requires a secured minimum appearance bond amount for certain defendants.
Questions? Okay, Senator Titus.
Thank you, Madam Chair. I have an amendment.
All right, we'll get that passed out.
Could I please have the revisor explain?
Sure. Thank you, Madam Chair. So this amendment, the first change is in the special sentencing rule. We talked about when someone is on supervision for a previous felony and their criminal history falls into an A through E category, then a sentence imposed shall be presumptive imprisonment. This would change it to require that the person be on supervision or in custody for a non-drug felony. So if you are on supervision for a drug felony and you commit a new non-drug felony, this would no longer apply to you. The special sentencing rule is already only in the non-drug statute, so it wouldn't apply to people who are committing new drug offenses. The second change is on page 14 related to the departure. You'll remember that no downward durational or dispositional departure was going to be allowed. This would change that to say that no such departure is allowed unless the departure is an agreed recommendation of both parties. So that would allow for those in some certain circumstances. On page 16, you're changing some of the bail provisions. Right now, the court has to find that you have not been charged with a drug severity level 1, 2, or 3 felony. This is going to add in an off-grid felony or any person felony. So it'll apply those bail changes to more people, more offenders. And then on page 17, in the, you'll see on page 16, the first requirement is that the person is a lawful resident of the state of Kansas. And then on page 17, currently it just says is a resident of the state of Kansas. So we're adding the word lawful there just to make it consistent. And then on page 19, similar to the downward departure, the amendment would add a section that says that the court can modify the bond or reduce the amount of bond without an evidentiary hearing and written findings if both parties have agreed to that proposed bond, except in no case shall it be an own recognizance bond. And I can take any questions.
Thank you. Senator Titus, did you want to explain further, or are there questions?
Thank you, Madam Chair. I'll just add, that I know there was a lot of work behind the scenes to put this together. I don't want to represent that everybody is 100% happy with this, but it significantly reduces the bed count, which was one of the major concerns. It deals with some of the 123 drug issues. It really tightens it up. I think, at the end of the day, is this going to cause more people to not be released? Yeah, that's the intent of the bill. So that's why we'll never get 100% agreement on this, but I think it's good policy to move forward with.
Thank you. Committee, is there discussion or a second? Senator Shane with the second. Any further discussion? All right, seeing none, you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries, and we're back on the bill. Committee, I have another amendment to pass out. It was what, when the Attorney General was here testifying, he had mentioned an amendment, and this would be the amendment. So once we have that passed out, we will ask the reviser to explain.
Okay, thank you, Madam Chair. So all of these changes are contained in the bond provision. So on page 15, you'll see that the amendment would add a requirement that if such person is not a citizen of the United States, their immigration status has to be verified with the federal government pursuant to 8 U.S.C. Section 1373. And there shall be a rebuttable presumption that a person who has been determined to be an alien who's unlawfully present in the United States is a flight risk. So they would have to overcome that presumption. And then on page 16, that language that we just talked about, lawful resident of the state of Kansas, that's going away. And it's being replaced with is a citizen of the United States or is an alien who's lawfully present in the United States and whose status has been verified, like we talked about previously. And then that same change would be made over on page 17 in that identical language. And I can take any questions. I would note that actually by doing this, you're removing the requirement that they be a resident of Kansas. You're just requiring that they be in the United States lawfully.
So how does this impact the amendment that we just put on that included you had to be a lawful resident of the state of Kansas?
Madam Chair, my thought would be if you adopt this, then you're overriding that amendment, so that language would be removed. So that was really just a technical cleanup to match, make the provision on pages 16 and 17 match. 16 had lawful, 17 didn't have lawful. So if you wanted to make this change, I think this would override that change.
But it wouldn't override the rest of the amendments that we just put on?
Correct.
Right, okay.
Just that one word change.
So this amendment provides some clarification or some extra?
Perhaps. I mean, if that's what you want to describe. Right now, you have to be a lawful resident of the state of Kansas. And this says you have to be a citizen of the United States or an alien who is lawfully present in the United States and whose status has been verified. So it's removing that that part about being a lawful resident of the state. And then it's also adding the presumption that if you are here unlawfully, you're presumed to be a flight risk.
Thank you, and that would help determine detention or?
Pretrial release on bond.
Okay, got it. Okay, yes. Okay, are there other questions for the reviser? Yes, Senator Reichman.
Sorry, with all these questions, I'm still a little concerned, I'm not concerned, messed up. I'm not quite following all this. Is the reason why this amendment right here is the idea that if they're not a lawful resident or whatever, they may have to be a flight risk or something like that, and they got to put that in considerations before they go along. What we're doing with this bill? I know it's a bad question, but I'm just kind of, thank you.
Sure. Thank you, Madam Chair. I think I understand the question. So if you'll recall the rest of the bill, there's several areas where the court is required to make a finding that the person is not a flight risk and sometimes that the person is not a danger to public safety. And so what this essentially does is to say, if you are not a citizen and you're not here lawfully, which is required to be verified under this federal statute, then you are presumed to be a flight risk. And then you would have to overcome that presumption. So it kind of shifts the burden, if you will.
Thank you. Committee, other questions? Senator Shane.
Thank you, Madam Chair. I'm wondering, so the current version is a lawful resident of the state of Kansas, and so I'm wondering if, in the case of this assessment, if we would say that it matters if the individual is a U.S. citizen but from the state of New Mexico, if they would also pose a flight risk, if there was a reason to be a legal resident of Kansas as opposed to being a legal U.S. citizen. And I feel like the answer to that is probably yes, and I'm wondering if we should conceptually modify this amendment where we maintain the language of a lawful resident of the state of Kansas and as a citizen of the United States, et cetera. But anyway, that's.
Right, and appreciate the concern and the suggestion. I think with, if we start adopting conceptual amendments, it'll get a little too messy for our reviser when we're talking about substantive. I know we do that on changing the enactment date, but it's certainly something that in conference would be something we would be discussing. Are there other discussion or questions? Is there a second on the motion? Senator Rose, because I looked over there first, sorry. Any further discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. We're back on the bill. If there's no further discussion, Senator Rose.
I was just going to move the bill if we're ready for that.
Perfect. Yes, sir.
Okay, thank you, Chair.
Oh, hold on just a moment. Committee, we heard some discussion about the amount of setting the amount of bail and whether that was too high or too low. We had heard it had already been amended down halfway. I didn't know whether we should amend that lower again, if there was any appetite to do that. I do have an amendment to do that, but if there's no concern of the committee where the amounts are, I'm not going to offer the amendment, but and we could discuss further in conference, but yes, Senator Bowers.
Thank you, Madam Chairman. That is a concern that I've heard several times. So if you make the motion, I'll second it so we can have a discussion and see where we land. I'm quite content to do
Okay.
that.
Sure, yes, we'll go ahead and pass out the amendment then, and you'll see the amendment halves those dollar amounts on page 19 of the bill, but we'll wait till it gets passed out. So you all have the amendment and a second from Senator Bowers. Is there any discussion? Senator Titus.
Thank you, Madam Chair. At this point, pretty significant changes were made in the House to this as proposed, so I'm not inclined to lower these any farther. I don't, for the purpose of this bill, I'm not sure we're really keeping in line with that by lowering them a second time.
Thank you. Further discussion? Yes, Senator Bowers.
Thank you, Madam Chair. And maybe this is for the reviser. On a previous amendment that we passed out, let's see if I can see a number on it. Proponent changes is listed. And on the back page, it gives the court can modify the bond. Could it be done lower? Could that lowering the amount be done through that last paragraph of B on page 19? That would be my question. Thank you, Madam Chair.
Thank you, Madam Chair. Senator Bowers, it can, but both parties have to have agreed to that proposed bond, and it would still have to be a surety bond. It couldn't be a owner cognizance bond, but it could be lowered if both parties agree to that.
Thank you.
Thank you. That, Madam Chair, that does help me knowing we have that previous amendment on there as well. And I do appreciate the conversation that we've had.
Sure. So should we move forward then with the motion on the amendment? And I think we all have heard the motion and the discussion. And so all those in favor signify by saying aye. All those opposed, no? No. Okay. The motion fails. We are back on the bill. Is there any further discussion or a motion? Senator Titus.
Thank you, Madam Chair. I move that the committee recommend House Bill 2444 as amended favorably for passage.
Thank you. Is there a second? Senator Bowser. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. Committee, we do have another bill to pull up, House Bill 2639. And 2639, if you'll recall, is the stabilization centers for our youth. And do we need a brief summary from the reviser? I think we just heard this yesterday. You'll remember there was some discussion about definition of crossover youth, so I have an amendment to help clarify that, if we'll pass that out. And there were a couple of different definitions talked about, and we heard from, I think, DCF, DOC as well, and from the Office of Child Advocate. So this is the definition proposed by the Office of Child Advocate. And I've talked with some other proponents of the bill, and they are good with this. And if not, we can talk about the details in conference, but if we get there. So you'll see the definition and the changes. We'll ask the reviser to explain.
Sure, thank you, Madam Chair. So this would just essentially create a list for that definition. So a crossover youth would be a young person 10 years of age or older who's at risk of being adjudicated or has already been adjudicated as one of three things: a child in need of care, due in whole or in part to conduct or involvement in the juvenile justice system, or allegations that could result in involvement in the juvenile justice system, or any level of concurrent involvement with the child welfare and juvenile justice systems.
With that, is there any discussion or questions? Not seeing any. Is there a second? Senator Rose, any further discussion? Seeing none, Senator Reichman.
Thank you. Now, if I heard you right, you said both sides were agreeable to this amendment. Thank you.
Thank you, Senator Reichman. This definition kind of contains some of what everybody was offering. It's not exactly what everyone had offered, but we're going to have to put a definition forward, and thought this was a good one. It's from the Office of the Child Advocate, not from a particular department, and so thought this was a good choice. Any further questions, discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill. Any discussion or a motion? Senator Rose.
I can make a motion?
That'd be great.
Okay. So I move we pass House Bill 2639 as amended favorably to the full Senate.
Is there a second? Senator Clays. All those in favor signify by saying aye. Those opposed, no. The motion carries. We have one last one, committee, for today, and it's House Bill 2762. 2762, and if you'll recall, it concerns those who are considered a person in a position of authority in a school for improper sexual relations. And with that, I do have an amendment, which will pass out, but while I'll explain that what happens if you're graduated high school, you're a college student, and you're in a relationship with someone who's in the high school, over 18, and you're volunteering, for instance, to judge a debate competition or a DECA competition, how would this apply to you? So with that, we'll have the reviser explain.
Thank you, Madam Chair. So if you'll look at the definition of a person in a position of authority for a school on page 5, you have to be one of three things. You have to be not a student enrolled at that school, you have to be delegated authority by the school to interact with students, and you have to meet one of three other criteria. Either you're a volunteer, you're designated or assigned to provide services for a school, or you're a contractor or an employee of a contractor. So what Senator Warren was mentioning is if say you're a college freshman, you're coming back to judge a debate competition, you're not a student who's enrolled at the school anymore, you're given authority to interact with students at the school, and you're volunteering at the school. So that's going to put you in this definition. So what this amendment would do is remove the volunteer for a school. It would clarify the designated or assigned to provide services for a school to be that you're designated or assigned through your employment. So this is the prong that you heard about, like from the Ed Clump with the law enforcement entities. Some student resource officers are not necessarily contractors. They're just assigned through their duties to perform those services, but that's always going to be through your employment. So just trying to tighten that up, and we can take any questions.
Thank you. Any questions? Discussion? Not seeing any. Is this something we want to have a second on, or, yeah, Senator Reichman with the second? Any discussion, questions? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill. And if there are no further questions, I'll entertain a motion. Senator Shane.
Thank you, Madam Chair. I move the committee pass House Bill 2762 as amended favorably.
Thank you. Is there a second? Senator Titus. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. All right, now we can open up our hearing. We do have, thank you for your hard work there, committee. We do have lunch provided for committee and staff, so we can get these hearings underway and concluded today. So with that, then, we will open the hearing on House Bill 2589, prohibiting the Secretary for Children and Families from accepting anonymous reports of child abuse or neglect, requiring the Secretary to inform anonymous reporters of such prohibition and other pertinent information regarding reporting child abuse and neglect, and allowing law enforcement agencies to accept anonymous reports of child abuse or neglect. And a brief from the revisor.
Thank you, Madam Chair. House Bill 2589 amends KSA 382223. This is the statute governing reporting of child abuse or neglect. In subsection B, the information of the report would require including the source of the information being provided, the name, telephone number, and residential address of the reporter. Subsection C would prohibit the Secretary from accepting, transmitting, or assigning a report for investigation unless the person reporting has provided that information that's required. The House committee added an amendment to provide that the Secretary shall transmit a report to a law enforcement agency if such person does not provide that identifying information, and there is either serious physical harm to, or serious deterioration of, or sexual abuse of the child, and action is required to protect such child. The bill also clarifies that law enforcement would be able to accept a report anonymously, or when a person is unwilling to provide that information to the Department for Children and Families. The bill amends subsection E to require that when a person is attempting to report anonymously and does not provide the Secretary with the information required, the Secretary would be required to inform the person that the Secretary is prohibited from accepting that report unless the person provides that information, and when identifiable information is confidential and not disclosed under state law. If a person is still unwilling to provide that information, the Secretary shall inform the person of alternative ways to report their concerns, including referrals to community services. The bill also amends the section to include a statement that such information required by the proposed amendments would be confidential as provided for in the Kansas Code for the Care of Children. The House committee also added a subsection I to provide the honor before the first day of the regular session of the legislature in 2027, and on the first day of the regular session every year thereafter, the Secretary would be required to submit a report on data concerning reports made to and received by the Secretary, and any reports that are transmitted to a law enforcement agency. That would have to be given to the House of Representatives Committee on Child Welfare and to the Foster Care and Joint Committee on Child Welfare Oversight. I would note there that there's no Senate committee in there right now, so for your consideration. And I can take any questions.
Thank you. Senator Clays.
Thank you, Madam Chair. You mentioned that they had an amendment, and evidently that amendment sends the information to local law enforcement. Is that correct?
So if you look, I'll find you the exact place where that is. So if you look on page 4, starting at lines 28, that's where it says the Secretary shall not accept a report or transmit that information if the person doesn't provide the identifying information. The House committee added a provision that says the Secretary shall transmit a report to a law enforcement agency if the person does not give their identifying information. And there's a serious physical harm to, serious deterioration of, or sexual abuse of the child, and action is required to protect that child. So if the Secretary were to receive an anonymous report and the person said, I'm not going to give you this information, but the Secretary had reason to believe that there's serious physical harm and action is required, then they would be required to transmit that report to law enforcement, even though there was no identifying information.
Okay, and maybe this is for the proponents, or I guess I'm wondering at this point what this bill is actually doing then. So if they're anonymous and then they, report child abuse, then it's still being reported.
So if those two factors are met, then it would still be reported, it would be reported to law enforcement, carried on, yeah. And I think that would be a good topic probably to discuss with the proponents.
Okay, thank you.
Thank you. Senator Bowser.
Thank you, Madam Chair. The reviser just answered my question. Thank you.
Thank you. Do you have what the vote was in the House?
Don't. I actually did bring the SUP note up here, though, so it probably
I think
says it.
it's,
I'm not used to reading these, but
116-0.
there you go.
Okay, all right, great, thank you. That was a phone a friend right there. So any other questions? Not seeing any. Then we have worked hard. We do want to make sure that we can get out at a good time. So we're going to ask conferees to limit their testimony to 2 minutes. And with that, then we will have proponent conferee Representative Timothy Johnson, Kansas House of Representatives, 38th District. If you'll please introduce yourself and welcome to committee.
Thank you so much, Committee Chair Warren, Vice Chair Titus, and our ranking minority Corson. House Bill 2589 is a culmination of 3 years' work for me. I'm a former law enforcement officer with 31 years' experience and background educational. This is a critical issue for protecting families. I'm not going to go over what my written testimony is all, but I want you to understand the key term here is confidential versus anonymous. We're taking away anonymous in terms of taking a report if it's not given, but still at all cost protecting the identity of a person who does make that report. It cannot be revealed except by order of a judge. So we are not taking away that provision. Next, one of the key issues are the numbers, and statistically, my research over the last 3 years has shown the great number of anonymous calls that do not result in any form of substantiation. You have those stats. My research came from the social work program at the University of Kansas and also looking at national stats, which you do now have. I want to thank those who will be in opposition to this is a very caring individual, and I hope you will at least consider her thoughts because of her work with the Child Death Review Board. Nothing in House Bill 2589 deletes protections of confidentiality. That is always there. Nothing.
1 minute. You have 1 minute remaining.
Okay. So I ask for this because this was a cumulative effort by all of our social work groups. In fact, they helped to write this bill. And I did, in fact, work with the county attorney in my area, someone I work with on a regular basis. So I do know the county and district attorneys for the state were aware of this bill because we consulted with him and we worked very well with him. I thank you for all the work you do, and I would stand for questions so I can go back and work your 1616 bill.
Thank you, Representative. Yes, let's hear from both representatives first, and then we'll open it up for questions for the two representatives. We do have Representative Dave Bueller, Kansas House of Representatives, 40th District. Please introduce yourself and welcome to committee.
Morning, Madam Chair. Representative Dave Bueller, House District 40. I want to put a face and a name on this bill. It's not just 2589, it is Rob and Karen Large. I bet each one of you has a Rob and Karen Large in your district. I met them 3 years ago. Rob and Karen have been the victims of an ex-spouse who has very carefully weaponized DCF and the state agencies. And so the bottom line is this: if it's a crime to knowingly make a false police report, it should be a crime to knowingly use a state agency to go after an ex-spouse. And when that happens, and you can look at my testimony, when you can turn and use DCF to get into and make claims of false sexual abuse, drug use, et cetera, what happened to them, what happened to Rob is near bankruptcy, is loss of his parental rights. Hadn't seen his daughter for over 3 years. I know that there are people that would oppose this bill, but they haven't helped Rob and Karen Large. Rob has testified for 2 years, and I think the third year with written testimony / interim committees. There's been no help to him. And he's basically saying, and again, I would go back, he's not the only one in my district. There's another woman named Angelina Lawson, same case. Look around in your districts. Do you know someone who has been the victim of this? This is what this bill is for. You saw the support in the House. I would ask and urge your support in this committee. I know that there will people come up here and say that this isn't necessary and that there are things we have to weigh here. We also have an obligation to defend the Rob and Karen Larges of the world, because this happens all the time and there is no satisfaction for them. So again, if it's a crime to make a false police report, it should be a misdemeanor at least to make a false claim with DCF. One other thing as I close, what we look at here, for those in the military, if you're similar to the Uniform Code of Military Justice, this is very similar to restricted and unrestricted reporting, so it can work. It does work in the military. And with that, I would stand for questions.
Thank you, appreciate it. Questions for the representatives? Senator Clays.
Thank you, Madam Chair. So I guess since you're up there, but it's also for the previous speaker. The previous speaker said a great number, and you have those stats. The stats that I saw, and maybe overlooked them, so please correct me, is that there was 54% of all anonymous reports received were assigned. That comes to 2,230 anonymous reports. That means half cleared the screening threshold. But it doesn't say of those assigned how many were substantiated. If you guys have that number, I'd like to hear it. If you don't, I mean, I would just remind the committee to understand that, you know, we're being asked to close a reporting pathway without knowing how many of those anonymous reports coming through were actually catching real abuse.
Okay, I can answer part of that. So when we had the hearing in the House, we did not have the stats that you have today, so that was obtained since February. To get the other information has not been given to us yet. I have looked at the statistics for other regions and other areas, but not for this time period. And that is one of the critical reasons we amended our bill at the request of DCF and law enforcement, is that there will be a reporting requirement that is now in this bill, so that now we'll have annual statistics, and it must be reported here to the legislature, so that we will have that 1 year from now. We'll know exactly what our numbers are.
Can I follow up? Okay, yeah, I mean, but we're not representing those regions, and so it'd be more interesting, I think, and useful if we actually had data for our state. I do have just one other question just to walk through. So if you take a look at how New York did it, since we're going to talk about other states, they actually exempted children under the age of 18, because, you know, if you walk through a scenario where a 14-year-old has a sibling that's being abused, you know, it's a pretty tough threshold for them to call and then, you know, be the reporter. And I know it's considered confidential, but still, that's, you know, you're evidently badgering them on the phone to say, hey, you know, if you don't give me the information, then this isn't, you know, we're not going to play ball. And so I mean, I have a concern there. I think that you know, carving out under 18 for this bill as an amendment would probably make it a little bit more amenable. I have to say I'm not inclined to support it, despite the 116-0. I think closing a pathway to reporting, I've just seen too much abuse, and I know maybe it's a low number, but a low number is still a number of kids that are being abused and being caught by anonymous reporting. So anyway, I appreciate you coming with this bill today, though. Thank you.
Thank you, Representative. Do you have any concern that removing anonymous, yet keeping it confidential, right? Removing anonymous would have a chilling effect on the number of valid calls that get made?
I don't believe so, because we have in place several laws. One of those, the mandated reporters, which we have addressed each of the last 3 years here in the legislature to enforce those. And in my county, when the school district didn't do that, they prosecuted them. And so, especially like in a youngster who wants to make a report, if they share that with a school counselor, anyone else, this will be reported. And there are many avenues for that to be done if someone else suspects that or talks with a younger person. My personal experience as a child abuse investigator is that we will get that information.
Thank you, committee. Any other questions for the representatives? Not seeing any, then thank you very much, and appreciate your testimony and being here. Next, we will hear from Crystal Hedrick, CEO, Children's Alliance of Kansas. Please introduce yourself and welcome to committee.
Morning, Madam Chair, members of the committee. My name is Crystal Hedrick. I serve as the CEO of the Children's Alliance of Kansas. We're a statewide association representing the private child welfare providers across the state. So our child protection system depends on timely, accurate reports so that professionals can intervene when kids are at risk. This bill clarifies reporting requirements by requiring reporters to provide identifying information when making a report to DCF. And there's a couple changes here that are important to us. First, having that reporter information on the front end allows investigators to follow up when they need additional information, so they can do that in a more timely manner. Anonymous reports can sometimes lead to a lack of sufficient evidence and make us kind of circle the wagon to get the information that we need on the front end. Second, the bill, as you've heard previously, prevents or helps prevent weaponization of the reporting system. While we know that most reports are made in good faith, sometimes it can be used in personal disputes and retaliatory situations that you've heard about today. Each investigation requires a lot of time from our CPS staff at a time when workforce challenges are a very real thing for us. So we want to ensure that the resources that we do have are going to kids who are truly at risk and victims of abuse and neglect. So again, just want to reiterate, this bill preserves the confidentiality protections for anyone who would be reporting, and law enforcement still has the ability to receive anonymous reports. So there is flexibility when necessary. So in short, this can help us have more supportive investigations on the front end. So I'm happy to stand for questions at the appropriate time.
Thank you, appreciate it. Next, Tanya Keys, Deputy Secretary, Department for Children and Families. Please introduce yourself and welcome to committee.
Thank you, Chair Warren and committee. I'm Tanya Keys, Deputy Secretary for the Department for Children and Families. House Bill 2589 adds positive outcomes for families. Requiring a reporter's contact information helps us with timely contact with the family. It helps us develop a safety plan, and it helps us in the required joint response with law enforcement as required in KSA 382226B. Having more information helps us support families. This bill is good for families. We have a little bit of data in the testimony, but annually we receive about 70,000 reports into the Kansas Protection Report Center for Kansas. Of those 70,000, about 6,000 reports are coming from someone who is an anonymous reporter. This bill would change that and reinforce that we need to do everything we can to get their contact information so we can help the family. Other parts of the bill, some of those aren't currently within DCF policy. We would change our policies to be able to be compliant with the policy, and we would proceed with changing rules and regulations as needed around this as necessary. So I'm happy to stand for questions. My testimony has a lot more information on our procedures and policies and some data. I could answer a question that was previously asked regarding substantiation, if that's okay. Of all of our reports that we assign, 96% of reports are unsubstantiated for all reports. We can follow up and get data on whether or not the reporter was anonymous, but we do know 96% of all reports are unsubstantiated. And thank you, and I'm happy to answer questions when appropriate.
Sure, thank you, appreciate it. Next, we'll hear from Carrie Leonard, Office of the Child Advocate. Please introduce yourself and welcome to committee.
Good morning. Thank you, Madam Chair, members of the committee. My name is Carrie Leonard with the Office of Child Advocate. And I stand here this morning as a proponent, and I put with caution. When I testified in front of the House, OCA stood as a neutral the bill. However, following some work of the House and committee members and stakeholders, they did make some amendments that did address a number of the concerns that I had in regards to the bill. But I stand here with caution, and I think that Senator Clays had addressed some of those, which is there is some concern that it could not only deter those that may be wanting to use the system for fraudulent reporting, to use it to harass and abuse someone else, which I know is one of the goals. And I think that's an important goal, and to recognize the number of reports. But we also want to make sure that we're also not deterring those who may want to self-report, who may be a victim themselves. There's also some concerns that it may be a deterrent for those who, for whatever reason, they've experienced a negative experience with law enforcement or DCF, and so they're reluctant to share their information and invite those entities into their lives. With that said, there are some safeguards to mitigate those concerns that are in place. One of those is ensuring that DCF does provide notice requirements and other pathways for those who want to remain anonymous. In addition, the House amendments did ensure that if there's enough information and it rises to the level that DCF can transmit that information to law enforcement, and that was an important change that our office felt needed to be made, as well as the reporting mechanism. We don't know of those 6,000 people, if they no longer had the ability to report as anonymous, would they share their information? And so, and also just really ensuring that it doesn't impact the safety of children overall. So making sure that we have good data and reporting if this moves forward. And Madam Chair, I'd be happy to stand for questions at the appropriate time.
Thank you. Appreciate it. Do we have anyone else wishing to testify proponent? Then we do have written proponent testimony from Brenna Vizosky, Campaign Director, Kansas Appleseed, and Gail Kozad, Kansas Children's Service League. Any questions for the proponents? No. Senator Clays.
Thank you, Madam Chair. So I was looking at some data, and I guess in some states like New York, they're saying 6%. So again, we don't have data for Kansas, but even at 6%, we're looking at 200 kids that were, that an anonymous report came in, and they were found to actually be abused. That's a substantial number. I'm using Kansas numbers. I'm taking the 6% and putting it with the Kansas numbers, not the New York numbers. To me, that's a pretty significant number of kids that we're just going to sweep under the rug. Also, you know, this doesn't really deter false reporting. I mean, you know, you can just give a fake name and, you know, have a burner phone or something like that and put in a false name. And, you know, one of the previous individuals, you know, mentioned the difference between anonymous and confidential and that distinction. I just wonder how many other people know that distinction. So when you call up and you say, you know, I'm going to report this, and they say that you can't be anonymous, especially a young child, or they, you know, we had to have it explained to us, the difference between anonymous and confidential. Evidently somebody felt like that was important here. Is that going to, you know, is anybody else going to have that difficulty and decide not to report because they don't understand that distinction? So I know that's three questions, but I think they're, honestly, I think they're just kill shots for this bill. I just don't see how this bill got 116 to 0 in the House. It doesn't seem like it's a bill that's effective. If anything, it seems like it's going to create more problems than not. Thank you.
Thank you. Was there a question that a conferee, 3 questions for our conferees? If anyone wants to step up and answer, maybe you could repeat them quickly.
Sure. Sorry, I put a little bit of commentary in there, and that probably, but one is, you know, it doesn't appear it's effective at all just because of the false reporting can still happen because you can give a fake name. Is that not true? So that's question one. The other question is, you know, what of those 200 kids in Kansas that were part of an anonymous reporting that were in fact being abused? Let's just focus on those 2.
Thank you. Please go ahead and reintroduce yourself.
Thank you. Tanya Keys with the Department for Children and Families, Deputy Secretary. Regarding the question on information that we receive from a reporter, we take in good faith what their contact information is that they report. So I believe your question was about someone could give false information or a false name. Maybe interpreted that wrong, but that is correct that when someone calls us and provides the contact information, at the time of our call and as we're listening to the person who has worries about the family, we do take that information in good faith.
Thank you. Senator Hill.
Thank you, Madam Chair, and I'm not sure who to ask this question to, but it's my understanding in reading this that the law enforcement can still take an anonymous report. Is that correct?
Yes, Chair and Senator, yes, that's my understanding as well on what the bill sets forth.
So if somebody calls into the secretary and is unwilling to provide information, I believe it says that they will be referred to law enforcement if there's allegation of serious issues.
Yes, Chair and Senator, yes, thank you. There's very specific conditions upon which, yes, if that circumstance met the definition, DCF or Protection Report Center would forward that information to law enforcement.
And my final question is, we've been assured confidentiality. Wow, that's pretty hard to ensure, isn't it?
Thank you for the question. It is difficult to ensure. What we would be ensuring and sharing is that the state law is that it is confidential and that our staff and our abilities and interactions with families, that we would not reveal any confidential information. But certainly it might be difficult to ensure confidentiality in total, but in our responsibilities, we can ensure that our actions will assure confidential procedures.
Isn't the purpose of this bill to provide sharing of that information in circumstances where it's warranted?
Thank you for the question. My understanding of the purpose of this bill is to require contact information from all reporters because it's helpful to families and helps with assessment of safety and a thorough engagement with the family.
But there's a provision in here for criminal prosecution if it is false. So, I mean, if nobody knows that information, I mean, somebody has to be provided that information, correct?
Yes, thank you for the question. If DCF receives a request for reporter information from law enforcement, we are able to provide that to law enforcement within some provisions. So there are specific provisions with regard to specified and necessary access of reporter information that's currently in statute that DCF can provide that information to a law enforcement agency if requested.
Okay, thank you for clearing those things up. Thank you, Madam Chair.
Thank you. And just a follow-up question to that. If the family who's being reported about, if the family requests, well, who made that report? Is it DCF's policy today that that information about the reporter would be provided to the family?
Thank you for the question. No, information regarding who a reporter is not provided to the family by a DCF child protection specialist. It's confidential and we're unable to share that information.
And would the bill change anything about what you just said? About DCF's policy that they can't disclose who the reporter is to the family, who the allegations are about?
This bill does not set forward any change to our current policy and current law. The information on the reporter remains confidential with exception to very specific provisions of releasing that information to law enforcement when requested.
So they could go investigate, and I think there's another exception if ordered by a court of law.
Yes, thank you.
Okay, thank you. I appreciate it. Senator Rose.
Thank you, Chair. The reason for this bill is to protect Kansans from false accusations of child abuse. Do you agree that that is a valid concern that needs legislation to solve?
Yes, DCF is a proponent of this bill.
Okay. Thank you, Chair. Do you know of any better ways to solve this issue than this current approach in this legislation?
Thank you for the question. What I appreciate about this bill is that it sets forth certain conversation points that a DCF child protection specialist would need to have in conversation with the reporter. We'll be explaining confidentiality. Our current practice is really to gather as much as we can from a reporter. We already want to have reporter information so that we can, again, engage the family. And someone who's calling cares about the family and knows the family. We can include them in safety planning or other supports for the family. So reporter information is very important to us. This bill reinforces and has values and beliefs that show that it is important to have and require contact information. Could there be better ways? There might be better ways to have dialogue or appreciative inquiry with the reporter so that we can help them understand how important it is for us to have contact information so they can continue to follow up and help with the family as long as they wish to be engaged. My experience in my career, I have been in roles of both receiving reports, taking reports, doing initial screening decisions for reports in my career with the agency. My experience is most anonymous reporters have a relationship with the family. They are not strangers. They have good information. They want to support the family, and we want their contact information so that we can help the family, and they can too be involved in a way that's really positive for outcomes for the family.
Thank you, Senator Shane.
Thank you, Madam Chair. So I'm certain that this topic probably has been debated for a long time when it comes to reports to law enforcement. And as a society, we've landed on there's more benefit to allow anonymous tip reporting and anonymous reporting to law enforcement, and that the cost of that is outweighed by the benefits. What makes reports to DCF different?
The roles and responsibilities for DCF as it relates to concerns regarding child abuse or neglect, or perhaps a family in need of an assessment or services, are to assess information if there's a worry for abuse or neglect, determine whether or not abuse or neglect occurred. That's best done in our role, in our responsibilities for safety, to engage everyone in that family's network who can help with the safety plan and help be a resource for the family. For example, if the worry is lack of supervision, might be connecting the family with supports in their family, in their neighborhood who could help with supervision. So the context of our work and our purpose and role is we want to know who can help the family and gather those. That's why it's important to have the reporter information, because they might be a great resource for the family for the purposes of our work of assessing and supporting and wrapping around a family to get them meaningful resources to help with the worry about family well-being. Not all of our reports received are regarding suspected abuse or neglect. We, in our role, receive an array and a continuum of child and family well-being concerns from folks who care a lot about a family and are giving us a call.
I guess, one of my concerns, and I appreciate that the bill says that the secretary shall transmit a report to a law enforcement agency if there's an anonymous report, but I feel like there's a little bit of, if it's good for the goose, it's good for the gander. And the consequence of not doing an initial workup of an anonymous report is potentially that a child is abused, neglected, or killed. And so as I thinking about the cost benefit, these are some of the things that I'm wondering. When it comes to mandatory reporting law, I actually had a bill on mandatory reporting last year, and I've had some interest in this topic. The prosecutor who has and now there's a couple of prosecutors now, but the prosecutor who went to prosecute a case for failure to perform mandatory reporting responsibilities, to his knowledge, it was the first time in Kansas history that the charge had actually ever been brought. We do have provisions in mandatory reporting law that willfully or knowingly making a false report pursuant to the section is a Class B misdemeanor. Could the problem be there would be no way to know that a report is being filed by a vindictive ex-spouse trying to cause child custody issues unless you actually know that it was the vindictive ex-spouse that was calling and making the report. So could the issue be lack of willingness to refer for prosecution or to investigate something that is already a crime?
Thank you for the question. I'm not sure I have enough experience to be able to answer that in determining the roles and responsibilities of our agency and the information we have. I don't know that I'm able to answer that. I don't know if any of my colleagues might be better to answer that.
Is there another person who wants to reply or not? So, okay. Or do you have your, okay, thank you. Senator Hill.
Thank you, Madam Chair. This is a little bit, and you're kind of getting the heavy lifting here today, so thank you for your for your willingness to take our questions. But I think the concern that has kind of been batted around a little bit here by the committee is the child that actually is in need of care, and the anonymous caller calls in and it would not be willing to give their contact information. In your opinion, would anonymous callers, when they are confronted with the verbiage that's in here, that they cannot accept an anonymous tip, would those callers, okay, understanding that they cared enough about the situation to call to start with, when confronted with that, in your opinion, would they provide that information?
Go ahead.
Thank you, Chair, and thank you, Senator, for the question. With my experience that I have in taking calls and doing initial screening determinations, if this were state law and we were proceeding with what's in this bill of having those meaningful conversations with a reporter, engaging them and explaining to them it is law, it helps us with the families, yes, I think individuals would provide their contact information. We are currently having some of those conversations and sharing the importance of it. I think it does work. We want to have appreciative inquiry with reporters and listen to everything they say. And I do think we can engage and help folks understand that it really helps the family when we have your full information. So yes, I do believe that.
Thank you. Senator Shane.
Thank you for your indulgence, Madam Chair. I guess one other question. We've had historical challenges, and I think in some ways it's become better over time, but we still struggle with DCF to, in my view, appropriately coordinate and report concerns of criminal elements to these cases to law enforcement. And it continues to be an ongoing struggle. So what in this bill would help make that better, where we still see issues, whether that's in the course of an investigation, we see drug paraphernalia in someone's residence, if it is that there's clear evidence of aggravated battery and maybe it takes too long to get law enforcement involved, or a law enforcement investigation is not appropriately triggered. Does this help alleviate any of those concerns?
Thank you for the question. There are current provisions within law that support joint investigation. There are requirements also that DCF share the results and conclusions of our investigations when they're substantiated with district or county attorneys. This bill, probably most directly related to that, is the provision where if the aspects where the amendment that happened so that we are able to transmit a report to law enforcement. That's most closely related, but there have been recent changes to law. For example, last July, it changed where DCF is now responding within 24 hours contact to a family when the report is from law enforcement. So we're going out 7 days a week and getting information back to law enforcement within 24 hours of our contact with the family. So last year, House Bill 2075 helped with that. But specific to your question about this bill, probably most related is the amendment made by the House committee that DCF shall transmit a report to law enforcement in those certain circumstances. That's what I would offer as an answer.
Thank you. We're going to go ahead and move on to opponent conferees. And thank you very much. We're going to hear from Sarah Hortenstein, Division Chief, Youth Services, Office of the Attorney General.
Thank you, Chairwoman Warren and members of the committee. My name is Sarah Hortenstein. I serve as the Division Chief of Youth Services at the Attorney General's Office. And for the last 11 years, I've also served as the Executive Director of the Kansas State Child Death Review Board. On behalf of my agencies and the children whose deaths we review and whose outcomes may have been different had someone reported concerns, on their behalf, I stand in opposition to this bill. The reason this bill was introduced was because there was malicious and false reporting made, and that is a crime. It's serious. We need to take it seriously. But our solution to this problem right now is to reduce or to eliminate the ability to make anonymous reporting. This is not okay for our Kansas kids. I've provided several examples in my written testimony that really talk about what anonymous reporting can look like and why those reporters need and want to stay anonymous. These are real reasons. These are not malicious reports. These are legitimate, good faith reports. But the process underneath this bill would require when someone calls to make a report to DCF and they say, hey, I need to make a report, DCF will say, okay, what's your name, telephone, address? And if they say, I don't want to give that, DCF would then tell that person, I'm sorry, we do not accept anonymous reporting. If you would like to make an anonymous report, you will need to call law enforcement. This puts our system in a very big imbalance, and it leaves children at risk because now that reporter who in good faith, who has information that could help a person, a child not suffer abuse and neglect, now has to decide, am I going to give my information or am I going to stay silent? Kansas does not have universal mandated reporting laws like some of the other states who have passed this bill. Texas, for example, who passed this bill, every adult over the age of 18 is mandated to report abuse and neglect of a child. Kansas doesn't have this. We're not the same. So we are really putting children at risk. There's been questions asked about data. I was provided data right before this hearing that talks about how many children's lives may have been saved because of anonymous reports. I know I don't have much time left, so I really wish this committee would maybe ask me a little bit about that and maybe ask me about some of the main reasons I feel like we should allow anonymous reporting when I'm able to stand for questions. Thank you, committee.
Sure, thank you, appreciate it. Next, we will hear from William Hurst IV, Assistant District Attorney, Johnson County. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Thank you, committee members. My name is Will Hurst. I'm an Assistant District Attorney in Johnson County. I've been in this business for 19 years. I'm on the Board of Directors for ks.gov, and I'm here on behalf of our organization to speak in opposition to this bill. I would encourage this committee to dig into the stats that DCF provided. If you look at that, it shows that in fiscal year 2025, there were 70,000 reports made total about kids in bad situations. Only 3% of those, in only 3% of those situations, did you have an anonymous report that led to an investigation. So I, by no means, am trying to minimize the stories that we've heard of malicious reporting or people having an axe to grind. But if the narrative is that there is rampant use or abuse of this system, the stats don't bear that out. This bill is primarily flawed for two reasons. If the goal is to get rid of vindictive anonymous reporting, it doesn't do that. Instead, if I have an axe to grind with someone, Now, instead of calling DCF, I'm calling law enforcement. And if I'm being accused as a parent of something that I did not do, would you rather have that conversation with a DCF employee or a uniformed police officer? Would you rather have that allegation against you be in an anonymous, confidential DCF report or in a police report that's subject to an Open Records Act? So again, if the goal is to prevent folks with an axe to grind from using this system to go after somebody, you haven't done that. You've just dragged law enforcement into it. Second thing, and then I'll close, is this is going to have a chilling effect. I know that folks say, well, it's going to be confidential. I'm just telling you, based on experience, people are going to be reluctant. I would encourage this committee to look. I know the Office of the Child Advocate was here today as a proponent. On the House side, they were neutral, and they put in their testimony that they were concerned that victims of abuse themselves might also be deterred from self-reporting if they believe that by disclosing their identity as a reporter, it would make them less safe. I could not agree more. So I'll just close by saying this. I know that there are times where the system is used for things it shouldn't be used for, but that's not going away with this. And I would be more than willing, our group would be more than willing to work with folks on the other side to come up with a finer-tuned solution. But right now, this bill is, I would equate it to burning down the house to kill a spider. So I'm opposed to this. Our group is opposed to this. And again, thank you, Madam Chair, and I'll stand for questions at the appropriate time.
Thank you, appreciate it. Any other person wishing to testify as opponent? Then we do have opponent testimony written from Michael Kage, District Attorney for Shawnee County. We'll open it up for any questions, and we're going to hear from our neutral, and then we're going to grab lunch and conclude our last two hearings. But with that then, any questions for opponents? Senator Rose.
Thank you, Chair. I have a question for Sarah. You mentioned that other states that have this kind of legislation that they're mandatory reporting for all adults. Would you support this legislation more if Kansas had that mandatory reporting requirement?
Please go ahead and reintroduce yourself.
Thank you, Sarah Hortenstein. I appreciate the question. And I would feel more comfortable for Kansas children and their safety if we had universal mandatory reporting for adults and if we did not silence anonymous reports that are made in good faith.
Thank you. Senator Hill.
Thank you, Madam Chair. My question's actually for Mr. Hurst. Thank you for your testimony, and thank both sides for their concern for kids. I think that is universal here.
Yes, sir.
The question I had, you cited some numbers there, and you said about 3% of the actual cases that were investigated came from anonymous tips. Is that, am I quoting you correctly?
I had it written out with a lot more detail. The 2-minute thing was throwing me off, so I was trying to go a little fast. So I'll be a little more clear about it. So DCF stated that in 2025, there were 70,000 reports that were made of any kind. Of that 70,000, there were 6% that were anonymous. Of that 6%, half of that they took action on. So if you look at that 70,000, when you had an anonymous report, only 3% of the time was DCF taking action on that anonymous report.
Would you go a little further into what taking action means?
So, and perhaps actually one of the proponents would be better at detailing that. My limited knowledge is essentially they're going to look into it. And are they going to see, is this something that has some, for lack of a better term, some meat on the bone? Or is this something, if they're not going to look into it, because it's completely frivolous?
So you don't have any number about, of those 3% resulted in change of placement, prosecution, et cetera, et cetera?
Senator, I don't. I know that Senator Clays talked about wanting to have stats as well. I was going off of what DCF provided. I would be interested in knowing the stats as well, but I do not have them, sir.
Okay, thank you.
Thank you.
Senator Shane.
Thank you, Madam Chair. I would like to hear how many lives of children were saved or made better through anonymous reporting, if that number could be shared, if it's available.
I'll let you take a shot at it.
Madam Chair, Senator, the information that Representative Howerton shared with me right before this committee, what I'm seeing here mimics the last conferee, but what it says here is that anonymous reporters who made these, it looks like a total of 73 children over these last 2 fiscal years, because of anonymous report, removed from that dangerous situation, if I am reading this data correctly. So 70 or more lives of children were potentially saved by anonymous reporting. I don't have the full scope of the data, but to me, that's plenty of children that have been saved by anonymous reports.
Thank you. Any other questions? Not seeing Senator Shane.
Just one statement. If either research or the agency could provide, I would think that if this was an issue, there should be a data point on number of reports that appeared to have been dismissed because they were filed maliciously or fraudulently. And I don't see that anywhere in the testimony or data that was submitted. As a matter of fact, for the information as why anonymous reports were not assigned, I don't see a single line item for fraudulent or malicious reporting. And the number one reason is that it did not meet the statutory definition of a child in need of care. Second most common reason was information in the report is already assessed or being assessed. So that would be, I think, good information to have.
Thank you, committee. No further questions. Then we will hear from neutral proponent Ed Klump, neutral conferee Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Ed Klump with the associations, the chair listed, save my 2 minutes. I just want to start out on page 1 of my testimony. I kind of outline why we're neutral. We understand what the problem is we're trying to address. Anonymous information does not equal bad information. However, anonymous information clearly does capture more false reporting than otherwise. I want to jump back to page 2, though, to get to the meat of what we want to discuss with you. The first full paragraph on page 2, we tell you why Section 1 was stricken from the bill by the House, and we recommend that stay stricken. In the second paragraph, we point out page 4, lines 30 to 36. When I had our people review this, they had a very difficult time understanding how that would possibly work and exactly what was being said. We just asked the reviser to take another look at that and see if there's a way to clarify that a little bit. If our people's having trouble understanding it, I think it at least deserves a second look. And then in the third paragraph, we talk about the penalty. You'll notice the penalty's been stricken in this. It was a Class B misdemeanor. There was some that believed it didn't apply to anybody but the mandatory reporters. We disagree with that. We think it applied to even the anonymous reporters or anybody that wasn't mandated to report. There's also KSA 21-5904, which includes, it's titled law enforcement, interference with law enforcement, but it also includes interference with law enforcement or a state investigative agency. So that is in there too. It was stricken because it was duplicative and it created a legal issue with 2 of them in there together. I'll point out interference under the criminal statute is a felony if you falsely report a felony. It's a misdemeanor if you report anything else. And in the fourth paragraph, lines 6 through 4, page 6, lines 4 through 7, this could be interpreted to not be able to share certain information with law enforcement from DCF. We don't think that's the intent. We would appreciate some kind of a statement clarifying that that still needs to be shared with law enforcement just so we don't go back to the days we were having several years ago before we got that clarified. I'll stand for questions. And if we don't get to your questions, you all know how to get hold of me.
Thank you, appreciate it. Committee, any questions? Senator Clays.
Thank you, Madam Chair, and thank you for coming with your neutral testimony today. You make a good point that, you know, the signal to noise ratio for anonymous reporting isn't so great. But would you agree that if the stakes are high, that even a low signal to noise ratio is something we should respond to? For example, bomb threats, often there's not a bomb, more often than not, way more often than not. Probably a number that's pretty close to this, but we still respond to bomb threats. Whereas maybe something like, hey, this neighbor's not mowing their lawn, maybe that one maybe want a higher signal, you know, when people driving around checking out something that's kind of a low stake. So I feel like that's being lost a little bit here. You know, when we look at these stats, you know, even if you're going to, you know, improve your ability to, you know, survive cancer by 5%, that seems low, but 5% when you have cancer seems pretty awesome if you know, take this or that pill. So I think that's getting lost in this conversation, is that this is high stakes. These are children that are being abused, and, you know, overlooking that just feels so criminal that you're just going to say, well, you know, if that person didn't give their name, then we're just going to bypass it. Anyway.
I would agree it is high stakes. I also would point out, in law enforcement, we deal with anonymous information daily. Neighbors won't tell us who they are when they call about a noise complaint from a neighbor at 3 in the morning. Sometimes they don't want to call when there's just suspicious activity happening at the house next door, because they have to live next door to those people. And yes, we respond to bomb threats. We respond to false accusations of an active shooter. I mean, we have to respond and look. And the difference in anonymous information is it's not that you have it, it's how you deal with it. And we have guidelines that have been established by case law. In a criminal case, how we deal with anonymous reporting, we have to verify a significant part of that in order to use that in any action we take. But it doesn't stop us from going inquiring, to going to watching and seeing. It prevents us from having a Terry stop, but it does not prevent us to walking up and say, hi, how are you doing? So there's guidelines on how we do that. So you're exactly right. And I talk a lot about balance and issues up here. And the balance here is between safety of children and protecting people from these false accusations, which is a horrible, horrible situation for people to be in, and very costly, has been brought up.
Thank you. Senator Rose. Okay.
Thank you, Chair. How can we better protect Kansans who have been falsely accused?
Yeah, you know, I don't know. That's a difficult question. I think one thing is you make clear there is a penalty for doing that when they're reporting. I think the penalties under the criminal code that will apply, they're a misdemeanor if you're reporting non-felony. If you're reporting a felony, it's a felony to make that false report. I think that's significant, and I think you need to let people know that. The difficulty is you always got to prove who made that report, right? But the most important thing is that you handle that information in such a way that maybe you can't confirm it's false, but you can't confirm it's true either. And at that point, you just catalog the information. You don't throw it away. You catalog the information, but you don't act on it.
So I think it'd be helpful if the DCF representative could speak to that, but we might not have time.
Let's go ahead, and we've had a full day, but we'll speak offline if that's all right. So yes, Senator Hill.
Thank you, Madam Chair. Thank you, Sheriff, for being here. When you take an anonymous report, do you really take an anonymous report? I mean, if you have a cell phone number or you have some way to identify that caller, do you actually record that?
So it depends on how we receive the information. You know, if it comes in on 911, we have the call, the number where the call was from. That's not always that person's phone, but it's a place to start looking back. Do we go to that extent? We will if that develops into something serious and we want to try to get more investigative information. But we can try to respect people's requests to be anonymous, especially like in neighborhood things, because that can just create into more neighborhood issues sometimes. So we try to go and we look. A lot of these anonymous reports come to us in our non-911 lines because we try to get people not to use 911 if it's not an urgent situation. And so sometimes we do not have that information, but sometimes we do.
Okay, thank you.
Thank you. And if there are no neutral conferees, that's the hearing then. Appreciate everyone's testimony, and we will close the hearing on House Bill 2589, and we're going to take a quick break to grab some lunch, and then have 2 hearings on bills that don't have any opponents listed as conferees. So thank you, everyone, and we're going to stand in recess for just a minute. All right, thank you. We are back, and we're going to then open the hearing on House Bill 2601, establishing a registry for child abuse and neglect to be maintained by the Secretary for Children and Families, and providing for registration and expungement processes that include administrative hearings and opportunities for subsequent appeals. With that, a brief from the reviser.
Thank you, Madam Chair. Section 1 creates a new section of law. It would establish a child abuse and neglect registry to be maintained by the Department for Children and Families. If the Secretary investigates a report of child abuse and neglect and substantiates that report, then the Secretary would be required to place that person on the registry, as long as the person has been provided notice and an opportunity for hearing. The section requires that such notice and hearing shall be conducted in accordance with the Kansas Administrative Procedure Act. The person may waive their right to a hearing and not contest the placement if they so choose. That waiver shall not be presented as evidence or an admission of guilt under any proceeding held under the Act. Under the Act, the presiding officer of a proceeding may be the Secretary. This section requires that the presiding officer of the proceeding initiated not be the Secretary or a person designated by the Secretary. A person who is the subject of the proceeding may be represented by counsel, including counsel appointed by the district court in an open child in need of care proceeding. In those proceedings, the presiding officer shall enter an order containing findings of fact and whether the evidence supports the Secretary's determination that the report is substantiated. If that officer finds that by a preponderance of the evidence that the report is substantiated, the officer shall order the Secretary to place the person on the registry. If not, then the Secretary shall be ordered by the court to not place that person on the registry. If ordered to be placed on the registry, the person may appeal that decision to the district court within 30 days. And that 30-day change was a change made in House committee. When a county or district attorney has initiated criminal proceedings against a person for a crime against a child or alleging that such person has abused or neglected a child, the attorney shall transmit information regarding that petition to the Secretary so that the Secretary may investigate and place that person on the registry. If a person is convicted or adjudicated of having committed a crime against a child or found to have abused or neglected a child, the court shall order the Secretary to place the person on the registry. The new section also establishes expungement processes for this registry. The Secretary may expunge a person's name from the registry when the person has requested the expungement. 3 years have elapsed, and the Secretary has considered the nature and severity of the abuse and neglect case, the number of any substantiated reports of abuse and neglect involving the applicant, the circumstances that no longer contribute to the finding, whether the applicant was a juvenile at the time of the finding, and actions taken by the applicant to prevent the reoccurrence of abuse and neglect. After an individual has been on the registry for 20 years, then the Secretary shall review and may expunge the name of the individual using the criteria described above. On July 1st, 2027, any rule and regulation adopted by the Secretary concerning any child abuse and neglect registry shall be null, void, and unenforceable, and the Secretary shall adopt new rules and regulations. Information in the registry shall be confidential, except for a few places that you'll see. Those are the amendatory sections in the bill. The sole legal permanency guardian, assessments conducted by the Secretary for the purpose of adoption and the licensing of foster homes, child care facilities and daycares. All those processes currently check an existing registry that exists by the Secretary. So this bill amends those statutes to cross-reference to this new registry that's being created. This section shall not be construed to prohibit the Secretary from maintaining any registry that is required by federal law, and it's confidential and not disclosed or otherwise disclosed under federal law. And I can take any questions.
Thank you. Committee, any questions? Senator Shane.
Thank you, Madam Chair. Could you clarify, so who would actually, and you probably said it, but who would be able to view this registry? Would be the practical implementation and use? Is it like child care providers? Is it?
Thank you, Madam Chair. Senator Shane, I think that's a good question. I think if you look on page 3 about the confidentiality, it cross-references some other confidentiality statutes within the Child in Need of Care Code, but I don't think it's abundantly clear in this statute.
Okay, thank you.
Thank you. Other questions? Seeing none, then we'll go ahead and call proponent Conferee Representative Cindy Howerton, Kansas House of Representatives, 98th District. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Cindy Howerton, 98th District. I could answer that question before we start time if you want, or I could finish it up later.
We'll just finish it up later.
Okay.
Go ahead.
Okay. So how much time do I have?
2 minutes. Why don't you go ahead and answer that question so we don't have to circle back and
Okay.
it's fresh on everyone's mind.
Okay, so that registry, to check if someone is on that registry, it's an electronic process. It operates through a use of release form request from the person who needs the background check to DCF to share with the necessary agency. Results are sent via encrypted email. The agency is working on a new web-based portal to request checks. It costs $10 to do that. No fee for any state agency, and there's no fee for the listed Mentor Kansas partners, but $10 release form for private agencies and general public. So anyone can check it if they have the consent of the person they're going to check, but child care agencies have to check it to make sure they're not on the registry. Is that clear as mud?
Thank you. I think so. Go ahead.
Okay. So this bill came out of the conversations in a joint committee on child welfare last summer around mandated reporting and the results of investigation. The Child Abuse and Neglect Registry came up several times, so I started looking into it, and this is what I found. The Child Abuse and Neglect Registry is an administrative list created and managed by DCF. Statute requires child care facilities to check this registry before someone can be hired or volunteer. So I support that and believe that that part is good. My concern is that the process used to create and maintain the registry is not in statute. It is solely found in rules and regulations. Most people do not even know that this registry exists, yet there are 40,000 plus names on this list. To get on this list, a DCF investigator and possibly a supervisor determines the allegation is substantiated. And I can go into that if you're interested. But HB 2601 does not change that criteria for placement on the list. DCF then mails a letter to the person stating that the allegation has been substantiated. And on the bottom of that letter, in a box, there is a fine print that says they have 30 days to appeal and that they must wait 3 years to request an expungement. 2601 changes that and ensures due process by changing it from an appeal process to a hearing and gives citizens the opportunity to present a defense to the allegations against them. Currently, at the appeal, the administrative court has to assume that the agency is correct. This bill changes it to preponderance of evidence. Right now, if a person appeals that first decision and then wants to appeal that decision, it is then sent to the State Appeals Committee, who are 3 people appointed by DCF. And then they can go to the district court all the way to the Supreme Court. HB 2601 creates a hearing first, and then if there is an appeal, it would go directly to the court, skipping the DCF appointed committee. So 2601 defines the expungement process in statute. It's in section E1C and requires an automatic review after 20 years on the registry. So if an individual is on their registry for 20 years, they meet the criteria for the expungements defined in the statute, DCF will remove them. 2601 also provides that the county or district attorney transmit information regarding a petition to the secretary so that an individual may be placed on the registry. And I would ask that the committee pay specific attention to this. In further thought, I love our process, but the shall transmit could be may, giving DAs more discretion, and it says, and place the individual on the registry subject to this section. I would propose that it says, and make a finding of substantiation. So there will be 2 paths onto this registry, one from DCF, substantiating, which would create a hearing. The other from law enforcement could give evidence to the DCF secretary. They could open an investigation, substantiate, and then they could be placed on the registry. One of the concerns is that there are people that we don't have enough evidence criminally to prosecute, and there are some people that have been found guilty of child abuse and not substantiated, so they are not on this list. So we're trying to close that gap and get everybody that should be on the list, and everybody that shouldn't off the list. So HB 2601 creates statutory protection for this process and guarantees the right to a hearing and the opportunity to be heard before someone is permanently labeled by the state. It does not weaken child protection. It strengthens fairness and transparency and ensures that even in an administrative process, Kansans are not presumed guilty without a chance to defend themselves. I'll stand for questions.
Appreciate it. Thank you. Next, we will hear from Crystal Hedrick, CEO, Children's Alliance of Kansas. Please introduce yourself and welcome to committee.
Good afternoon, Madam Chair. My name is Crystal Hedrick. I serve as the CEO with the Children's Alliance. We're a statewide association representing the private child welfare providers across the state. We support the intention of House Bill 2601 and appreciate the focus on strengthening accountability and consistency within our child welfare system. There certainly is value in a centralized registry that has clear standards and transparency statewide. One of the hesitations or worries that we had on the House side was addressed through an amendment. Well, we just want to ensure that this system would replace any existing registry or process and would not be supplemental. Specifically, as we think about onboarding and retaining qualified child welfare practitioners and approving and licensing foster homes and kinship families and adoptive placements, and frankly, just allowing us to make timely permanency decisions for youth experiencing foster care. So in closing, we appreciate this committee's work and the House's work on this issue and look forward to continuing to collaborate with you on this. I'm happy to stand for questions.
Thank you, appreciate it. Next, we will hear from Tanya Keys, Deputy Secretary, Department for Children and Families. Please introduce yourself and welcome to committee.
Thank you. Tanya Keys, Deputy Secretary for the Department for Children and Families. Thanks for an opportunity to provide information on our support for this bill. As you've heard, there are a lot of these terms that are currently in Kansas administrative regulations. This bill would codify some of that information, so we would have it in state law. And we originally had concerns, and we appreciate all the House amendments for this. We are a proponent and support this bill as it reads and appreciate all the thoughtful consideration to make the amendments. If this bill passes, we'll engage the process to propose and update rules and regulations with regard to this information, and happy to stand for questions when appropriate.
Thank you, appreciate it. Any other proponents? Not seeing any. Committee, any questions? Senator Shane.
So I just want to clarify, so there was the $10 for another agency. In the opinion of DCF, would there be an issue of compelling a look at this registry in other professional realms where we might care if somebody had a credible accusation of child abuse and neglect, like
Go ahead,
teachers, nurses, what have you?
Reintroduce yourself, please.
Thank you. Tanya Keys with Department of Children and Families. Can you repeat that question again?
It sounds right now on a case-by-case basis that an external agency could request to see if somebody's on the registry. Would there be any issue with compelling looking at that registry for new teacher licensure, new nurse licensure, or things like that?
Thank you for the question. I believe that decision would reside with the board or the entity who wishes to have child abuse and neglect background checks as part of a condition of employment, or volunteers or anyone who would reside. We simply have the form, so different employers, for example, can use them. So in my opinion, it would be up to the entity that wishes to have that as part of their personnel policies and check. There are certain child care facilities let me see, I've got that in my testimony, 65-516, that's where the guidance is for those who are required to do so.
Thank you. I have a quick question for the representative. The bill addresses the registry for Department for Children and Families regarding children. There's also, I believe, a registry with KDADs, and maybe the Deputy Secretary would know this also. I think there's a registry for elder abuse too that has the same administrative process, but none of the due process protections offered in this bill. If that's kind of correct, would there be any opposition to putting in these same due process safeguards in place for the operation of KDAD's administrative proceedings.
Yeah, I have no objection to that. And you have a conferee that's neutral that could probably answer that question.
Okay,
as
great.
well.
I would think, if we're going to substantiate claims as a department, we want to offer those who are going to be substantiated against the opportunity to defend themselves and opportunity to be
And honestly, I
heard.
didn't look further than just this DCF registry, so that would be, I think it should be for all Kansans who have any kind of substantiation, so.
Okay, thank you. Any other questions? Not seeing any, then we will hear from neutral conferee Lauren Snell, Jr., Acting Director, Office of Administration Hearings. Please introduce yourself and welcome to committee.
Well, good afternoon. My name is Lauren Snell. I am the Acting Director of the Office of Administrative Hearings, and I appreciate the opportunity to come here as a neutral provider of testimony on this. And I'm only interested primarily in Section 1 of House Bill 2601. Obviously, the other sections don't really impact what we do. My basis for being here is because we are the agency that's responsible for hearing the appeals that you heard about in the little box that's on the notice of action that gets sent out in these cases. Those actions, when those appeals are filed, they come to our office. I provided written testimony that kind of describes the process that we go through with regards to each one of those. And so I'm not going to, in 2 minutes, there's no way that I could sum up how that goes. So I'll allow you to read that at your own leisure. But suffice it to say, we're not concerned about the changes that are going to occur with this particular bill in light of the fact that it's still going to end up coming to our office. It's still going to be done pursuant to the Kansas Administrative Procedures Act. And so whether it's a hearing based upon what I'm going to characterize it more as a complaint that would be filed essentially by DCF once they made this determination that somebody had been substantiated and they should be placed on the registry. So whether it comes to us in that form or whether it comes to us as an appeal of a notice of action, it really doesn't have any bearing on what we're going to do and how we're going to handle the case, except for it does remove that process of going before the State Appeals Committee after we actually make our decision on the case. Otherwise, what's in here, we do exactly that. We hear the case, we make a determination, we issue an order with findings of fact and conclusions of law, and we make the determination as to whether or not the action that was
1 minute. 1 minute remaining.
That was initiated by the Department for Children and Families should be affirmed, reversed, or remanded. And we would continue to do that based upon this, although we probably wouldn't do so much as far as remanding. It would either be affirming or denying the complaint or summary order, or however it ends up getting fashioned when it comes to us. I will say, if there is a concern that I have, and it's not a concern that I think really is detrimental to the bill, it's just the issue with regards to the attorney provision that's in there that says that an attorney who's been appointed through the district court can represent somebody who comes before our court as part of this process. My only concern in that is we do not have the ability to pay for or appoint attorneys for individuals who can't afford them. And so if you have an attorney who gets appointed by the district court in a child in need of care proceeding, for instance, and they were going to represent them in our proceedings as well, I would have a concern in how that was going to be paid for, just based upon the fact that we don't budget for appointing attorneys or have that kind of capability under our current statute. We are statutorily created, and so we're bound by that.
Thank you. The timer did go off. It made a different noise, so it was hard to hear, but if you want to wrap up.
Do you want me to answer the question with regards to the adult abuse issues?
Let's wait till we hear from all the neutral conferees. Thank you. Next, we will hear from Carrie Leonard, Office of the Child Advocate. Please introduce yourself and welcome.
Good afternoon, Madam Chair, members of the committee. My name is Carrie Leonard with the Office of Child Advocate, and I stand here today as a neutral entity in regards to HB 2601. We stand in support of the overall intent of the bill, particularly as I think you heard from a proponent conferee and the bringer of the bill, that really the goal is to close that gap, to ensure that those individuals that need to be on that registry are, and that those individuals that should not be or no longer need to be are then removed, and to have those procedural safeguards. Our office does continue to have some concerns in regards to that bill, as outlined in our testimony. The first one, and I think you just heard a moment ago, was really around that scope of the attorneys in regards to the provision on page 1, lines 31 through 34. We already have some challenges in regards to representation in our child in need of care cases. There's some concerns around their caseloads, around their pay. There's a report from the Judicial Council this year that really gives you a lot more information around that, and would encourage you to look at that. I have some concerns around them potentially then being appointed, or the requirement that they would need to be representing in administrative law hearings around that. So would ask that that section be looked at. The second concern is I believe that there's a potential unintended consequence in regards to child needed care hearings in particular when we think about child's time and the evidentiary hearings. Right now, oftentimes, when it comes to adjudication, you'll find that they're entering into no contest statements and waiving that right and moving forward with the case. If there is the potential impact that they would automatically be placed on the registry, I believe that you're going to see a decline in individuals entering those no contest statements unless there's some changes to this provision, which will then increase, I think, the length of time that cases are being heard in litigation and the potential impact then on the courts. So we just ask you to consider that. And with that, I would also just very quickly, just in response to the question by the chair, there is a post-audit, Kansas Legislative post-audit report that came out in July of 2025 that does look at all of the state agencies' registries around abuse, neglect, and exploitation. And I think that's a helpful set of information as you're looking at the impact of this bill potentially. And Madam Chair, I'd be happy to stand for questions.
Thank you. Appreciate it. Any other neutral conferees? Seeing none, then we'll open it up for any questions. I would like an answer on the KDAD's registry as well from Mr. Snell, if you can answer that.
Lauren Snell with the Office of Administrative Hearings. Yes, actually, right now we have two sources of adult abuse cases that come before us. They either come from the Kansas Department of Aging and Disability Services, or we also get adult abuse cases that come to us from the Department for Children and Families. So we actually get those on two fronts. And I believe in both circumstances, I'm looking to this deputy, I believe in both circumstances they do end up on that adult abuse, neglect, exploitation registry if they are affirmed by our office for having committed one of those three offenses as part of whatever action that they've been engaged in. So, but yes, the process is exactly the same. They get an action, or they get a notice from one of those two agencies. They can appeal it to our office. We make a finding, and then it's subject to going to the State Appeals Committee, either for the Department for Children and Families or for KDAD's. Actually, I take that back. The KDAD's cases do not end up going to a state appeals committee. They don't have a state appeals committee. So from KDAD's, it would actually go straight to district court at this particular point in time. But the other provisions aren't included.
Is the DCF registry, that's the same whether the victim is under 18 or an elder or any other? So would it be the same registry? I'm looking to put that into this bill if this bill advances. So
I believe there are two different registries that they have. There's an adult abuse registry. If you have committed abuse against an adult victim, then it is a separate registry. And then if you've committed abuse or against a child, then it's...
And would there be any opposition from the Office of Administrative Hearings to putting that in this bill as well?
No, none whatsoever. Okay. None whatsoever.
Thank you. Any other questions? Not seeing any. Ms. Leonard, you had said that if you take away the consent, it would have an impact on the courts, but the consent is before you get to the appeals process. The consent is about at the original determination of substantiated or not, right? And go ahead.
Madam Chair, and I may have tried to talk too fast.
I'm sorry, it's nature of the timing.
My concern is when you look at the bill on page 2, lines 21 through 24, there is a provision that says that if an individual is adjudicated or convicted, that they will, let me just make sure I'm reading it straight from the bill. If an individual is convicted or adjudicated to have committed the crime against a child, then the court shall order the secretary to place the individual on the registry. My concern, and this comes from my time as an attorney who is representing individuals, whether it be parents or someone else and the guardian ad litem, oftentimes someone will proceed with a no contest statement and move forward with adjudication rather than taking the time for an evidentiary hearing. And I believe that this, because of the impact of this, it may impact then what's happening right now in our courts.
So the practice today is that if someone's going to sign that consent, aren't they notified, hey, if you sign this, one of the consequences is you're going to be put on the registry? Do we not notify them of that?
That's Madam Chair, thank you. Right now, that's not an automatic. When it comes to the child in need of care case within the district court, if a person is adjudicated there, right now, they are not automatically placed on a registry. This would change that. So my suggestion, and I've talked with...
over in the district court, not
right, correct.
if you're, okay.
And I've talked with Representative Howerton, and I think she mentioned it in her testimony as well, a potential fix to just say that rather than being placed directly on the registry, that they could be substantiated, and then it would trigger the process.
Okay, great. Thanks for clarifying that. Any other questions? Not seeing any, thank you. Then we will close, excuse me, I need to ask, are there any opponents to the bill? Not seeing any, then we will close the hearing on 2601 and open the hearing on HB 2552, requiring criminal pre-sentence investigation reports and journal entries to be completed and submitted in the form and manner prescribed and approved by the Kansas Sentencing Commission. With that, a brief from the reviser.
Thank you, Madam Chair. House Bill 2552 has a few sections related to those PSIs. Section 1 amends KSA 216813. The criminal code statute relating to the preparation of a pre-sentence investigation report. Current law in subsection G requires those reports in any case in which the defendant has been convicted of a felony to be on a form and manner approved by the Kansas Sentencing Commission. This bill amends this provision to require the journal entries to be completed and submitted in the form and manner prescribed by the Commission. Section 2 amends KSA 223426, the Code of Criminal Procedure statute related to journal entries. Section 3 amends KSA 223426A. This is the Criminal Procedure Code statute related to journal entries for probation revocations. Current law in both of those requires journal entries to be recorded on a form prescribed by the Kansas Sentencing Commission. This bill amends both of them to require the journal entries to be completed and submitted on a form and manner prescribed by the Commission. Section 4 amends KSA 223439, the criminal procedure statute that requires the court to forward certain information to the Sentencing Commission. The bill adds a new subsection D to provide that all documents required to be forwarded to the Commission pursuant to the section shall be completed and submitted in the form and manner prescribed by the Commission. The court shall not receive or recognize as valid such documents that are completed in any other form or manner. And I would note that if this were to pass, it would go into effect on publication in the Register. And I can take any questions.
Are there any questions for the reviser? Seeing none, thank you. We will open up with Judge Sexton on WebEx.
Senator Titus, if I could have Director Schultz go first, and then I will piggyback on him if that's all right.
Okay, Mr. Schultz, welcome to committee.
Mr. Chair, members of the committee, thank you so much. Scott Schultz, Executive Director, on behalf of the Sentencing Commission. This is our bill that we introduced. If I, during the course of my testimony, subconsciously talk about consent calendar, chicken sandwiches, or waffle chips, please forgive me. I may do that. But this is a bill that we introduced based upon a technology that we currently have and that we would like to codify the use of it and by statewide. So many of you know we do actually, there are 3 forms that are used in felony sentencing. The pre-sentence investigation report that is done in all of those felony cases, the journal entry of sentencing, which documents what happened in every jurisdiction on for that, and then if they're placed on probation and things don't go well, they can be brought back, and there's a probation violation journal entry. We are required by statute to maintain all those, and so things that you do within this committee and legislatively changes those every year. And so up until this point, this has all been on paper. And so we put that out. Jurisdictions use it. It is used, all of these are used in every jurisdiction in the state. We are changing the statute with this bill. We ask for your support based upon the manner in which it is used. That basically is a product of the Kansas sentencing application that we have created. This is a cloud-based program that allows for entry of the pre-sentence investigation report as well as those other 2 sentencing journal entries in a electronic format. It also provides for a electronic signature module that allows for prosecutors as well as defense attorneys to sign electronically. And so that is the essentially the future of sentencing bill that you have before you. We certainly would ask, I don't know that we had, I managed not to make any of the House members mad, and they passed it 122 to 0. So we are hoping that you support it as well. This program is free to all of the users, stakeholders, which would be probation officers, prosecutors, as well as defense counsel. We've also got it integrated, or in the late stages of integration with the court's e-file system, and so that is actually being taken place actually as we speak. So once that actually occurs, judges will be able to, approve those journal entries just like they currently do in their system with OJA. So with that, the only item that I would say, we did have quite a few discussions in committee about the use of shall. And this is, we get into the legal nitty-gritty here. Despite what most of us may think as far as the difference between may and shall in case law doesn't always mean shall. It actually, there's a test that's actually done. One of those items in the test, and this is actually from the State versus Raschke case.
Right, I think we had 2-minute timer. His timer was awfully quiet, but go ahead and wrap up, please.
Okay, thank you, Madam Chair. The Raschke case is 289 Can 911. It sets out a 4-part test to determine whether shall actually means shall. And so we would ask with this situation, if the committee so chooses to work this, that it specifically mean that shall is mandatory rather than discretionary. So stand for questions at the appropriate time.
Thank you, appreciate it. And then we will hear from the Honorable Benjamin Sexton, Chair, Kansas Sentencing Commission. Please introduce yourself and welcome.
My name is Ben Sexton. I'm Chief Judge in the 8th Judicial District. Madam Chair, thank you very much for having me here today and members of the Judiciary Committee. Very excited about this bill. One thing is, and what Scott, Director Schultz said, is the accuracy. And you folks want accuracy when you're talking about bed numbers. Some districts haven't used a sentencing, form of the sentencing journal entry, and when they send it in, then the individuals at the Kansas Sentencing Commission have to by hand take that off the form that comes in and place it in the specific box. And you worry about consistency and you worry about accuracy. This takes that completely away. I'm also very excited about the fact that it's going to decrease the number of mistakes involved in these journal entries when they are sent in. If there's a mistake, the Department of Corrections will send a letter to you, and then you have to hold another hearing, bring everybody back in to make that correction. This app that Director Schultz talked about will alleviate that, because after the pre-sentence investigation is done, they're going to be able to press a button and 75% of the sentencing journal entry will be filled in from the pre-sentence report. That's going to cut
1 minute remaining.
that'll cut down on mistakes. Further, that app will make you fill in the specific areas necessary. So we have one courtroom in our district, that one county, that has another hearing to make sure these are done correctly, which is a horrible use of time. So in great hopes that this will alleviate that, and we would really, I ask you that you pass this on, if you could, please. Thank you. Thank you, Madam Chair.
Thank you, appreciate it. Any other conferees, proponent, neutral, or opponent? Not seeing any, then we will close the hearing on 2552 and thank everyone for their attention. And this helps with our workload for next week. And we will not be meeting tomorrow, March 13th. And we will, however, meet Monday at our regular time. So with that, then, meeting is adjourned. I'm sorry, didn't mean to close the hearing. Let's reopen the hearing real quick, and if there are any questions. Sorry, Senator Hill.
Thank you, Madam Chair. I had no real question, except I wondered if we got to ask questions. But since I have the microphone, I want to say hi to Judge Ben Sexton, a big hero of mine. So thank you for coming before the committee and testifying. And would you have problems if we put this on the consent calendar?
I would not be, so we can make that motion at the appropriate time.
Yep, thank you.
So go ahead, Judge.
I'm just going to thank you, Senator Hill, very much.
Appreciate it. And with that, then we will close the hearing. One other question, sorry, Senator Haley.
Just very briefly, thank you, Madam Chair. I want to thank both the judge and the director for being here. I do sit on the Sentencing Commission, and I do recall the shall versus may, and if there's some way we can clear or better codify the intent for shall, the specific intent that's either in here or not, I'd appreciate hearing that by the time we work the bill. And thank you again, Director Schultz and Judge Sexton. Thank you, Madam Chair.
Thank you. Okay, any other questions? Seeing none, then we will close the hearing on House Bill 2552. And thank you to our conferees for your patience while we work bills and while we had the hearings throughout the meeting today. With that, then, and thank you to our staff for their extraordinary work, and committee also, we accomplished a lot today. Appreciate it. With that, meeting adjourned.